Hello and good evening, everyone. Welcome to the course of Civil Litigation. We are going to start with chapter number 1, General Matters and the Overriding Objective. Before we begin discussing the actual content of the chapter, I want you to understand one very important thing about civil litigation. Students often make the mistake of trying to study civil litigation as 24 completely separate chapters. That is the wrong approach. You must treat civil litigation as one continuous civil case. If a client comes to you and says, I want to file a civil claim, you do not think I read this in chapter number 1 or I read this in chapter number 2. Instead, you combine everything together and identify the procedural stage the case has reached. This is exactly how questions in the exam work as well. The MCQs in the exam will place you in different procedural situations, and your task is to identify the stage before applying the rule. So, whenever we study any chapter, we must first understand its purpose and where it fits into the overall procedural journey of a civil claim. Now, let us begin with the purpose of chapter number 1. Imagine a very simple situation with me. I'm practicing as a lawyer in UK. I have my own law firm. I have been practicing for several years. And one day, a client named John comes to see me. John says, I want to bring a civil claim against Simon. Now, the moment John says this to me, the very first thing I need to think about is which court should this claim be issued in. That is the starting point of this entire chapter. For our purposes today, we will keep the court structure extremely simple. There are only two courts you need to focus on at this stage. The first is the county court, which you can think of as the smaller or ordinary civil court dealing with the majority of claims. The second is the high court, which you can think of as the bigger court dealing with larger, more complex, or more important cases. So, whenever a client says they want to sue someone, the first task of the lawyer is to determine whether the claim belongs in the county court or in the high court. Now, before we answer that question, there is one additional point you should understand. In some situations, the civil procedure rules, the white book itself, specifically indicate which court the claim should be issued in. Now, where the CPR expressly directs that a particular category of claim should be issued in a certain court, we simply follow the CPR. For example, defamation claims are generally issued in the High Court. However, in the majority of situations, the CPR does not expressly tell us which court to use. In those situations, it becomes our responsibility as lawyers to identify the correct court using the ordinary jurisdiction rules. So the question now becomes, how do we actually determine whether a claim belongs in the county court or in the high court? Whenever you are faced with a jurisdiction question in the exam, there are only three things you must identify. First, what is the nature of the claim? Second, what is the financial value of the claim? And third, is there any justification for using the high court instead of the county court? If you answer those three questions correctly, you will reach the correct court. Let us begin with the first question. The first thing I will ask John is, what is the nature of the claim? Is this a personal injury claim or a non-personal injury claim? This distinction is extremely important because different financial thresholds apply depending upon the category of claim. A personal injury claim means John has suffered some kind of physical or psychological injury. For example, John may say that Simon hit him with a car or that they were involved in a fight and John suffered injuries. Those are personal injury claims. A non personal injury claim is essentially every other type of civil claim that does not involve bodily or psychiatric injury. For example, breach of contract claims, property disputes, or professional negligence claims. Now, in response to my question, John will give me one of two possible answers. Either he will say that it is a personal injury claim, or he will say that it is a non personal injury claim. So let us deal with both categories one by one. We will begin with the first category. Suppose John tells me that this is a personal injury claim because Simon hit him with a car. Once we know that we are dealing with a personal injury claim, the next thing I naturally need to ask John is, what is the financial value of your claim? The reason this question matters is because the financial value determines whether the personal injury claim must be issued in the county court or the high court. For personal injury claims, the position is straightforward. If the value of the claim is less than 50,000, then the claim must be issued in the county court. There is no choice. However, if the claim is worth exactly 50,000 pounds or more than that, then the claimant has a choice. The claim may be issued either in the county court or in the high court. Now, many people assume that once the value reaches 50,000, the claim automatically belongs in the high court. That is incorrect. The correct position is that 50,000 or more merely creates a choice. It does not create an obligation to issue proceedings in the high court. Let us now move to the second category, namely non-personal injury claims. Suppose when I asked John whether this was a personal injury claim or a non-personal injury claim, John tells me that this is not a personal injury matter. He says that he had a contract with Simon. Simon breached the contract and caused him financial loss. Once we know that we are dealing with a non personal injury claim, the next thing I need to ask John is, what is the financial value of the claim? In non personal injury claims, the financial threshold we take into account is £100,000. If the value of the claim is £100,000 or less, then the claim must be issued in the county court. However, if the claim exceeds 100,000, then the claimant has a choice between the county court and the high court. Now remember one very important point. If the value in a non-personal injury claim is exactly £100,000, it does not create a choice. The claim must still be filed in the county court. The claimant gets a choice only where the value exceeds 100,000. Now this is different from personal injury claims where a value of exactly 50,000 still creates a choice between the county court and the high court. Now we know that in order to choose the correct court, we first identify the nature of the claim and then determine the financial value of the claim. Once we know the financial value, one of two things will happen, right? Either the claim must proceed in the county court, or the claimant may have a choice between issuing proceedings in the county court or in the high court, right? Now imagine John falls within one of these choice situations. For example, it is a personal injury claim worth £70,000, or perhaps a non personal injury claim worth £250,000. At that point, John may say to me, if I have a choice, then let us simply go to the High Court. Now, once John says that to me, I must explain something very important to him. Even where the claimant technically has a choice between the county court and the High Court is not merely a matter of personal preference or personal choice. A claimant cannot simply choose the High Court because they want to. The claimant must still justify why the High Court is the appropriate court for the case. So the next question becomes, what factors justify issuing proceedings in the High Court? The court primarily considers three factors. The first is the financial value of the claim. If the value is exceptionally high, that may justify using the High Court. Now remember carefully, simply crossing the threshold is not enough. For example, if the value of the personal injury claim is 50,050 pence, Technically, the claimant is eligible to issue proceedings in the High Court, but that does not mean the financial value genuinely justifies using the High Court. The value must be significantly high before financial value alone becomes a proper justification for issuing proceedings in the High Court. The second factor is the complexity of the case. Complexity can arise from many different things, right? Including the legal issues involved, the factual background, the remedies being sought, or the overall structure of the dispute itself. For example, the case may involve difficult legal issues, multiple contracts, or expert evidence is required. Now imagine John contracts with me. I subcontract with another person, and that person further transfers obligations to additional parties. Suddenly, four or five different parties become involved in the same litigation, right? That is exactly the type of situation that may justify issuing proceedings in the High Court because the matter becomes procedurally and legally complex. And the third factor is the public importance of the case. This means the dispute may affect the wider public, involve an important legal principle, or potentially create a precedent. Now, remember that decisions of the senior courts, particularly the High Court and above, may influence the lower courts. Therefore, where a case raises issues of wider public significance, that may justify the involvement of the High Court. Now, when it comes to these three factors, the claimant does not need to establish all three together before issuing proceedings in the High Court. Even one sufficiently strong factor may be enough. For example, the claim may involve exceptionally high financial value, or it may be highly complex, or it may raise issues of wider public importance. Any of these factors, if sufficiently significant, may justify issuing proceedings in the High Court. However, where none of these factors are properly present, the claim should ordinarily remain in the county court. Moving on, up until now, you will have noticed that the financial value of the claim primarily determines where proceedings should be issued. However, let us now consider a slightly different situation. Suppose John does not want damages at all. He wants an injunction preventing Simon from doing something. In that situation, we cannot apply the normal financial thresholds because the claim has no monetary value, right? So the question becomes, how do we determine the correct court where the claim is non monetary? In non monetary claims, the decision is based primarily upon two things: the complexity of the case or the public importance of the case. Therefore, if the matter is sufficiently complex or raises issues of sufficient public importance, it may proceed in the High Court. Otherwise, the claim will generally remain in the county court. Now, let us understand something very important. When we ask the client about the financial value of the claim, how do we actually calculate that financial value in order to determine whether it has crossed 50,000 in a personal injury claim or 100,000 in a non-personal injury claim? The concept is actually very easy to understand. Students often make mistakes in MCQs because they try to memorize which figures should be added when calculating the financial value of the claim. That is the wrong approach. I'm not teaching you what to add. I'm teaching you what to disregard when calculating the financial value of the claim. In MCQs, you will often be given many different figures. For example, the question may mention damage to John's car, damage to his phone, medical expenses, interest, legal cost, and so forth. The question then becomes, which of these figures actually matter when determining the financial value of the claim? The answer is that there are five things you must always disregard when calculating the financial value of the claim for jurisdiction purposes, namely cost, interest, counterclaims, social security benefits, and contributory negligence. Let us understand each of these one by one. The first is cost. Whenever I use the word cost throughout the civil litigation course, I'm generally referring to litigation expenses such as lawyers' fees, expert fees, and any other legal expense incurred in running the case. So if John says, I have already spent, let's say, £20,000 on lawyers and experts, I disregard that figure completely. Legal costs are not included when calculating the financial value of the claim. The second figure you disregard is interest. Interest is basically the additional amount that the court may grant in addition to damages or cost at the end of the case. So if my client says he will be able to secure £10,000 as interest, we do not take that into account. At this stage, we are only trying to determine which court should hear the claim. Therefore, interest is ignored when calculating the financial value of the claim. The third figure you disregard is counterclaim. Let us take a simple example. John sues Simon, but Simon also intends to bring a claim against John. That is a counterclaim. Suppose John's personal injury claim is worth 25,000, but Simon's counterclaim is worth 75,000. John cannot say because Simon's counterclaim exceeds 50,000, we now have a high court choice. That is incorrect. We disregard the value of the counterclaim entirely. We focus only on the value of John's own claim. The fourth figure you disregard is social security benefits. For example, suppose John suffered injuries and the government is paying him financial support while he is unable to work. Even if those benefits are substantial, let's say £50,000, they are disregarded when calculating the value of the claim for choosing the correct court. And the fifth figure you disregard is contributory negligence. Now, this concept is very important, and a lot of students often confuse it with counterclaim. A counterclaim means both parties are bringing separate claim against each other. Contributory negligence is different. Here, the defendant accepts some liability but argues that the claimant was also partly at fault. For example, Simon may say, yes, I caused the accident, but John was also negligent because he ignored the traffic signal. In such circumstances, the court may reduce the claimant's damages by a certain percentage. For example, 15% or 20%. However, for the purposes of calculating the financial value of the claim, you disregard allegations of contributory negligence. So even if the defendant argues that the claimant should suffer a 15% or 20% reduction because of contributory negligence, you ignore that reduction when deciding whether the claim crosses the relevant financial threshold. So always remember this structure. In exam questions, you may be given 10 or 15 different figures. Your task is not to panic. Your task is simply to identify and disregard the 5 excluded methods. Whatever remains after disregarding those 5 methods represents the true financial value of the claim. Now let us move on to deal with another concept. Imagine John comes to me and says he wants to file a claim. After looking at the matter, I advise him to issue proceedings in the High Court. However, later on, it turns out that I was wrong, and the claim should actually have been filed in the county court. So the question becomes, what happens if proceedings are issued in the wrong court? What powers does the court have in that situation? There are two possible outcomes. The first and the most common outcome is that the wrong court simply transfers the case to the correct court. So if the claim should have been issued in the county court, the High Court will transfer it to the county court. However, because the mistake was made on the claimant's side, the transfer cost may be imposed upon the claimant. basically the administrative cost of transferring the case from the High Court to the County Court or vice versa. However, there is also a second possibility, and this applies specifically where proceedings were wrongly issued in the High Court. In that situation, the High Court may decide not to transfer the case back to the County Court and may instead retain the case in the High Court itself. If that happens and the claimant later succeeds at trial, the High Court has discretion to impose a cost sanction of up to 25%. The sanction could be 5% or 10% or 15%, but not more than 25%, depending upon the circumstances of the case. Importantly, this reduction applies only to the claimant's litigation costs and does not reduce the claimant's damages themselves. So, for example, if John wins the case and would normally recover his legal costs from Simon, the court may reduce those recoverable legal costs as a penalty for wrongly issuing proceedings in the High Court. Now remember, this sanction is entirely discretionary and applies only where the claimant succeeds in the High Court. Now, to briefly revisit what we have discussed so far, we now understand how to choose the correct court, which primarily depends upon the nature and financial value of the claim, along with factors such as complexity and public importance in certain situations. Once we have identified the correct court, now the next step is to understand the procedure and discuss how claims are actually issued. The procedure will depend upon whether we have decided to issue proceedings in the county court or in the high court. Let us first discuss the procedure where the claim is to be issued in the county court. Suppose we determine that John's claim belongs in the county court. At that point, the next question becomes, how do we actually issue the claim? The answer depends upon whether the claim is monetary or non-monetary. Let us start with the monetary claims. If the claim is a county court money claim, then such claims are generally issued through the Civil National Business Center, commonly known as the CNBC, located in Northampton. Students often get confused here and think if John lives in Manchester, then he must issue proceedings in Manchester. Or if Simon lives in London, then the case must automatically begin in London. That is not how the system works for county court monetary claims, because these claims are centrally managed through the CNBC. So, practically speaking, what happens? John either sends the claim to the CNBC or physically goes there and files the claim. The CNBC then processes the claim and serves it upon Simon. If Simon wishes to defend the claim, the defense is also filed there. So once the initial procedural paperwork has been completed, the matter is then transferred to an appropriate county court hearing center for the actual hearing before a judge. So remember the sequence carefully. The claim begins at the CNBC, the paperwork is processed there, and only afterwards is the matter transferred to a local county court hearing center for hearings and further case management. Additionally, if it's a monetary claim to be filed in the county court, there is also an online system known as Money Claim Online, commonly referred to as MCOL. Through this system, the claimant, instead of filing the case in CNBC, has a choice to issue the claim electronically online, and the defendant may also file the defense online, making the process quicker and more convenient in straightforward cases. However, the money claim online is available only if two conditions are satisfied. Number one, the financial value of the claim must not exceed 100,000, and there must not be more than two defendants in the case. Therefore, not every county court monetary claim can be started through the money claim online. You could only use it if both the conditions are satisfied. Now let us consider the second category, namely non-monetary county court claims. Suppose John is not claiming money at all. Instead, wants a non-monetary remedy such as an injunction. In that situation, the claim does not go through the CNBC because the CNBC primarily deals with county court monetary claims. In such situations, the claimant may issue proceedings directly in any appropriate county court hearing center in the UK. We will now move to the second situation, namely, where the claimant has decided to issue proceedings in the High Court. The question then becomes, how are proceedings actually issued in the High Court? Suppose I advise John that the claim should properly be issued in the High Court. In that situation, proceedings may be issued either in the Royal Court of Justice in London or in one of the various High Court district registries located throughout England and Wales. The main High Court building is the Royal Court of Justice, commonly known as the RCJ. The district registries are essentially regional high court centers located in different cities. Therefore, if the claim belongs in the High Court, proceedings may generally be issued either in the Royal Court of Justice or in any appropriate district registry. We now turn to the final concept for today's chapter, namely the concept of overriding objective. Even though we are studying it in chapter number 1, you must understand that it influences the entire civil litigation process all the way from chapter number 1 to chapter number 24. So, what exactly is the overriding objective? The overriding objective is an obligation which requires the court, specifically the judge, to deal with cases justly and at proportionate cost. To understand this concept properly, focus on two keywords: just and proportionate. Just means the court must ensure fairness between the parties. Proportionate means the court must manage cases sensibly, efficiently, and without unnecessary expense. In practical terms, this means ensuring fairness between the parties, placing them on equal footing, trying to save the expense, and dealing with cases efficiently, and allocating the court's resources appropriately while taking into account the financial value, importance of the case, and complexity of the case. Let us now understand this with a few simple examples. Suppose John brings a claim worth only £5,000, but he wants 10 separate expert witnesses, 20 hearing days, and endless procedural applications. The court may say that this is disproportionate because the cost and complexity of the litigation are completely out of proportion to the financial value of the dispute itself. Similarly, suppose John is representing himself and does not fully understand procedural rules, whereas John has a large legal team with barristers and solicitors. The court may manage the case in a way that still ensures fairness between the parties while remaining neutral. The court is not there to become Simon's lawyer, but it may still take steps to ensure that one party does not gain an unfair procedural advantage. Now, let us take another example to better understand the entire idea of overriding objective. Suppose both parties are repeatedly asking for adjournments, filing unnecessary applications, and refusing to cooperate regarding simple procedural matters. The court may refuse those requests because they waste court time and increase cost. Now remember that the court system has limited resources, right? If one case occupies weeks of court time, that affects other litigants waiting for hearing as well. Therefore, the overriding objective is not concerned only with fairness between John and Simon individually. It is also concerned with the efficient administration of justice overall. Now, when we are talking about this duty, it is not confined to the judges. There is also a duty of actively managing the case on the parties, that is, the claimant and the defendant. So the parties in the case are expected to cooperate where appropriate, identify issues at an early stage, and avoid unnecessary disputes, and consider whether the matter can be resolved through methods such as ADR, for example, negotiations and mediation. So, in addition to the duty of overriding objective, there is also a duty of actively managing the case on the parties. So the parties also have to cooperate with one another. However, cooperation does not mean helping the other side run their case or reminding them about procedural deadlines. It simply means conducting litigation sensibly and efficiently. For example, suppose John's solicitor knows that only two issues are genuinely disputed but still insist on producing thousands of unnecessary documents purely to increase pressure and expense for Simon. That behavior would conflict with the spirit of the overriding objective because litigation should focus on the real issues, right? Not unnecessarily creating procedural warfare between the parties. Similarly, suppose Simon refuses mediation entirely without any proper reason and forces the matter all the way to trial, even though settlement was possible much earlier. The court may later take that into account when exercising discretion on cost. We will talk about cost in chapter number 24. So, we are just talking about that such conduct would be taken into account. Now, you must also understand why the overriding objective is so important. It is not merely a theoretical statement placed at the beginning of the CPR. Whenever the court exercises discretion, whether relating to extensions of time, case management decisions, relief from sanctions, or cost, the court is always guided by the overriding objective. That brings us to the end of chapter number 1. Although this chapter may initially appear introductory, it is actually one of the most important chapters in civil litigation because it forms the procedural foundation for everything we study later in the course. Thank you, everyone.